Donna Adelson was convicted and sentenced to life in prison yesterday, and today the grand jury was meeting in Tallahassee, listening to evidence on a high-profile case. Grand jury proceedings are secret, so the Wendy Adelson rumor mill has been churning all day. And tonight, we will bring you the facts. Is Wendy Adelson about to be indicted? Meanwhile, in Arkansas, a case and a story that everyone is talking about and everyone has an opinion about. A 14-year-old girl is victimized by a 67-year-old alleged predator. He gets caught, arrested, and is then let out on bond, but subjected to a protective order keeping him away from the 14-year-old girl. Then the 14-year-old girl goes missing. Her father begins the search and finds her in a car with the alleged predator. What happened next was a deadly confrontation where the predator is shot and killed, and now the father is charged with murder. But the story doesn't end there. Now that father is running for sheriff. Tonight, details and analysis of this very complicated situation. But first, grief and outrage converge as the trial of v.Bionca Ellis enters its most harrowing phase. The defendant stands accused of following 3-year-old Julian Wood and his mother into a supermarket parking lot, then stabbing Julian multiple times in his grocery cart and wounding his mother as she desperately tried to shield him. Witnesses, surveillance video, and the medical examiner testified to the brutality of the attack, but Ellis's defense is centered on her mental health. She has pleaded not guilty by reason of insanity, placing her mental state at the heart of the trial. The prosecution is pressing for aggravated murder, the defense pleading insanity. As a toddler's life and a mother's scream echo through the courtroom, the jury must untangle horror from mental illness to decide justice. And tonight, we have the latest from the courtroom. I'm Vinny Politan. Thank you so much for joining us tonight here on Closing Arguments. Great to have you aboard. She did it. There is no question about who killed little Julian. It was v.Bionca Ellis. She absolutely did it. The evidence is beyond compelling. Between eyewitnesses, the video, the weapon, everything, all the pieces fit incredibly. But if you look inside the courtroom and you look at v.Bionca Ellis, she's now medicated and seems to be a different person to a certain extent. She's not acting out. She's just kind of like sitting there. Remember, this is someone who was so unhinged and dangerous on that day, walking around with a knife that she stole, stalking a 3-year-old child, taking that child's life, completely out of control. And then afterwards, so? You just killed that child. So? Completely detached from any sense of what she did and how awful and how evil it was. Now, her defense is insanity, that at the time, she didn't understand what she was doing. She was somebody else. She suffers from mental illness. She suffers from schizophrenia. And if the jury finds her not guilty by reason of insanity, you'll often hear, that doesn't mean she goes home. No, she'll be locked up, but she won't be going to prison or jail. She'll be going to a secured facility. But let me tell you how that works. An insane killer can be released. It's not about what you did. It's about who you are. And if, in fact, she's found not guilty by reason of insanity, every 3 to 6 months, 9 months, she'll come into a courtroom and have the case evaluated by a judge. The judge will listen to the treating physicians who work for the state. And inevitably, over the course of time, these witnesses for the state, these experts, will tell the judge how well the patient, not the defendant, not the killer, but how well the patient is doing and how well the patient is responding to treatment. Of course they're going to say that. They're the people treating her. Do you think the treating physicians and doctors are going to come in and say, you know, nothing, we can't do anything with this one? No, eventually they will talk about how well the patient is responding. And they will inevitably recommend to the judge that the killer/patient get more and more freedom, whether it's a weekend visit with people, whether it's, you know, a day trip, whether it's, oh, you don't need to be in a secured facility anymore. Oh, you don't need to be in a facility at all. You can be treated as an outpatient. The problem is she's only not unhinged and dangerous when she's medicated. But if eventually she gets released, which can happen, who will be in charge of making sure she's medicated? She will be. And that was the problem initially. She decompensated, she became unhinged, and she took a life. That's why there's a lot at stake at this trial. A lot. And the decision made by this jury should not be taken lightly. Guilty, locked up forever. Not guilty by reason of insanity, we'll see. We'll see how the patient responds to treatment. So today, closing arguments. Let's take a look at the both sides kind of making their case for this jury, really about the mental state of this defendant.
Ladies and gentlemen, we are all together today because of the choices Bionca Ellis made on June 3rd of 2024. 50 seconds. We watched that defendant go directly to the houseware aisles, go through that bin, look up top of the knife block up there. She spends almost a minute looking through these knives. She doesn't pick the first one she sees. She finds the two favorites of hers, and then she walks out of the store. She made a decision that was careful, but she knew when she chose those knives what she was going to do. She was going to harm someone. She was going to take somebody's life. Pay attention. She's got two knives still behind her back, and she's looking around. Ladies and gentlemen, she's looking for a victim, and here it is. Ladies and gentlemen, this is the decision she makes after she's selected her weapon. These are the people she wants to harm. It's been decided. There is no question this defendant is schizophrenic. That's prong one. Bionca Ellis suffers from a severe mental disease of schizophrenia. However, the fact that she has that diagnosis does not mean that she didn't know what she did was wrong on June 3rd.
The state's strategy in this case has really been to normalize Bionca. They make the acknowledgement, and they have to concede because they can't get around it, that she's mentally ill. But they want to normalize her behavior on that day. There was nothing normal about Bionca Ellis on June 3rd. There's nothing normal about her behavior. I want you to look at Bionca Ellis. 1 week from the day of the incident, she's at her arraignment. She's smiling at her arraignment, even though it's been put forth to her that she could possibly receive the death penalty. Who smiles? Who does that 1 week after this incident? I take 2 steps back and ask you, I just really want you to think about this. Does it make sense for Bionca to be angry about money that she didn't receive from a police department, to seek a 3-year-old child out and stab a 3-year-old child because she was feeling that anger and that rage? Commonsensically, does that make sense?
We
We told you from the beginning that the one principal issue in this case is not going to be who did it or whether she did it. It's the issue of legal insanity. If the state proves all the elements beyond a reasonable doubt, she's saying, hold on, folks. I was legally insane, therefore should not be held responsible. There are folks that walk around us each and every day with mental illness, and they don't kill people.
There is a lot at stake. Mental illness is clear. Both sides are conceding that. Mental illness is a medical diagnosis. Insanity is a legal standard. There's a difference, a big, big difference. Let's bring in our think tank. Joining us tonight, criminal defense attorney Joseph Krowski Jr., criminal defense attorney, former head New Jersey County prosecutor v.Bionca is with us, and national parenting and family relationship expert Dr. Sue Kornbluth. Great to see everyone tonight. All right, Joe, let's start with you. Legal insanity. There is no guilty but mentally ill in Ohio. Some states have it. I think that's great. I think that's a way to treat people humanely. But if you have two choices, finding someone not guilty after doing what she did and finding someone guilty, this is not an easy decision for this jury. Not an easy one at all. What's the right call?
Well, it shouldn't be an easy decision. Unfortunately, I think it's going to be an easy decision for this jury. Our mental health system is broken in this country. It's broken in our court system. Statistically, these defenses work less than 1% of the time, and typically only if you have a sympathetic defendant and an unsympathetic victim. Here, you know, God rest his soul, little Julian, you do the juxtaposition between him and the defendant, Ellis. I think there's just too much of a visceral reaction from the testimony that this jury has heard. So I think that she is really up against it. And any defense that works less than 1% of the time is broken. And we really have to have a real conversation about that in this country, because we have a robust history of supposedly wanting to punish people for actions that they voluntarily undertake. That's not the case in this case in Ohio.
Good, Bob. I know you want to say something.
Yeah, no, I agree with everything that he just said. The case is.
Can I disagree, Bob? Bob, can I just throw something out there, Bob? I think it's misleading, though. I think it's misleading because aren't there hundreds and hundreds of cases where both sides agree that the defendant is not guilty by reason of insanity? They don't go to trial. So to say 1% works, well, that's where the state doesn't necessarily agree with the defense, right? I mean, let's be honest about this, Bob.
Well, I'm not arguing percentages. What I'm arguing, the point I was trying to make that I agree with Joe, was that you're dealing with a child, a baby, an innocent, complete innocent. The overwhelming emotionality of that in front of a jury, irrespective of the mental condition of the defendant, is virtually impossible for the defendant to overcome. Add to that now facts that show premeditation, the hiding of the knives, the goal-oriented conduct, the looking for the victim. Hey, there's no question. Guilty, or she's without a reasonable doubt mentally ill. But like you said, Vinny, that's not the standard. The standard is that she couldn't know the difference between right or wrong. So you got an unsympathetic defendant, a sympathetic victim, and you have very goal-oriented behavior. What you have here is a person who acted evilly, and that's what this jury is going to find.
Look, I have to chime in here. I think that the prosecution said it exactly right at the end, where she said to the jury or whoever was in the courtroom that you can commit a crime, but are you insane at the time that you are doing it? And furthermore, are you taking that knife and you planned it, or were you hearing voices at the time this was taking effect? And if you were hearing voices at the time that this was taking effect, then yes, could she be insane at the time she was doing this? But how do we really know that that happened at the time this was going on? That's the problem here for me. That's the problem with mental health.
She's got to know. The issue is whether she knew the difference between right or wrong.
So look, I think it's an oversimplification.
Go ahead, Joe.
Look, it's an oversimplification of the issue, and it was a simpleton prosecution. People that are mentally ill and have DSM-5 diagnoses like she does, she's schizophrenic, still have cognitive function on the spectrum. So they can still go into a store and grab a knife. They can still want to kill someone and plan out actually killing someone. That doesn't mean they appreciate the wrongfulness of their conduct. Mentally ill people are not necessarily catatonic in a rubber room. So look, what was their exit strategy? It's kind of res ipsa loquitur. It speaks for itself. Of course she was under a psychotic episode when she did this. Doesn't mean a jury will see it that way, but I see it that way.
And you broke out the Latin tonight, Joe. You win the argument with the Latin tonight, right? We're out of time here. Tomorrow morning, tune in to Julie Grant because she will have the verdict watch as it continues. The jury getting back to work first thing in the morning. When we come back, we're going to talk about this story out of Arkansas, a multi-layered story involving a man going after another man who went after his daughter. Plus, coming up next hour. Tonight on v.Bionca Investigates, for years, bodies buried in the sand told a story no one wanted to believe. Women vanishing, their lives cut short, their secrets hidden along Gilgo Beach. Now investigators say the truth behind those dunes is darker than anyone imagined. Could the answers to a decade of horror finally be uncovered as the accused goes to trial? Tonight, we investigate.
Join Court TV's v.Bionca with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
v.Bionca Investigates, tonight, 9/8 Central, only on Court TV.
Donna Adelson wasn't a regular mother.
She's the matriarch mastermind.
She's just being a parent, not a killer.
Victim to Verdict with Ted Rollins. Season finale, Saturday night at 8 Eastern and Pacific.
Only on Court TV.
Hello, Lone Oak. My name is Aaron Spencer. Many of you know my story. I'm the father who acted to protect his daughter when the system failed. I'm also a husband, a combat veteran of the 82nd Airborne Division, a contractor, and a farmer. And through my own fight for justice, I have seen firsthand the failures in law enforcement and in our circuit court. And I refuse to stand by while others face these same failures. That's why I'm announcing my candidacy to run for Lonoke County Sheriff. This campaign isn't about me. It's about every parent, every neighbor, every family who deserves to feel safe in their homes and safe in their community. It's about restoring trust, where neighbors know law enforcement is on their side and families know that they will not be left alone in a moment of need. Together, we can build a safer, stronger Lonoke County for every family. I'm Aaron Spencer, and I'm running for sheriff of Lonoke County.
Okay, so you're watching that, you wonder, why, there's sheriff races from coast to coast in counties everywhere. Why are we interested in this sheriff candidate in Arkansas? Well, it's because of the little reference he made at the top. You may know my story. Well, his story is a story that you need to hear and we need to tell and talk about tonight. Let's bring in Court TV field reporter Cody Thomas, who's been looking into this case. All right, Cody, let's talk about the story of Aaron Spencer.
So we got to start from the top, Vinny. Aaron Spencer, you heard him there, 82nd Airborne veteran, contractor, farmer, accused murderer now. Accused of murdering 67-year-old Michael Fosler. So what happened? What ensued here? This all happened about a year ago, October 2024, October 8th to be exact. One night, the family dog is barking. He gets up, he's waking out of his sleep, checks the house, makes sure everything's okay, goes in his daughter's room, his 14-year-old daughter's room, and she's done the whole stuffed animal in a hoodie act that you've seen in plenty of TV shows.
Right, yeah,
up.
you're gonna sneak out so you make it look like you're in bed.
So obviously he's, where's my daughter at? Hops in the car and goes searching around in the community, stumbles upon Michael Fosler's car. 14-year-old daughter is in the car with Michael Fosler.
How old is he?
67.
Okay.
So there's quite a bit of an age gap. So Spencer runs the car off the road, gets out, there's an altercation that ensues. He ends up killing or shooting Michael Fosler there on the scene. Spencer calls 911 himself. Ultimately, he gets arrested and charged with his murder. Now, the kicker here, 67-year-old Michael Fosler was out on bond, but he was previously charged with 43 felonies related to Spencer's underage daughter. We're talking child porn.
Wait, the same girl who's in the car there, he had 43 pending charges involving her as the victim.
Underage victim.
Wow.
Child porn, sexual assault, internet stalking, all of that. So he'd been, previously locked up for it, got out on bond awaiting trial for it, but he gets out on bond, comes back to get her again. So the current sheriff at the time, Sheriff John Staley in Lonoke County, put out this announcement, this press release video announcement here once it happened in reaction to the shooting. Let's take a listen.
I'm your Lonoke County Sheriff John Staley. In the early hours of Tuesday, October 8th, Lonoke County deputies responded to a report of a missing juvenile. While en route, got a call of a shooting. After consultation with the prosecuting attorney, an arrest was made with a preliminary charge of first-degree murder. Arkansas state law provides guidance on when and how charges are filed in criminal cases. As this is an ongoing investigation, only limited details can be released. As your sheriff, it is our duty to conduct a thorough and factual investigation. Law enforcement does not file charges. We gather evidence and submit a case to the prosecutor, who will then decide whether or not to file charges. Currently, official charges have not been filed. I have not, nor will I, advocate for any specific charge. This is a tragic situation, and my thoughts and prayers are with all those involved. We will continue our investigation and submit the findings to the prosecutor for review.
Now, Vinny, of course, that video came out a year ago. We now know those charges have officially been filed. He's facing second-degree murder. He also has an enhancement on that charge because he shot him with a firearm. So that's an extra 15 years, potential 15 years on top of the murder charge. But now, again, Aaron Spencer running for sheriff to replace that guy there in the same county that he was arrested in, the same county that he's awaiting trial in. And Vinny, that video we watched of him making his sheriff campaign announcement, I checked today on Facebook, has 10,000 likes, has been shared over 4,000 times. So there's an outpour of support for his campaign nationwide.
Yeah, I think I know where that's coming from, right?
Absolutely.
Okay, let's talk about the court filings on both sides. What's going on in this case?
There's been a lot going on in the last year. The state wanted a gag order. They got a gag order in December of 2024. That gag order has since been vacated in May of this year. So anyone who's anyone in the case can talk to whoever they want to about the case. But the most recent filing was in August. That was the defense's motion to dismiss. And they say it's based on what they say is a violation of the Fifth Amendment. And in that motion to dismiss, the argument at the beginning, it says in part, quote, the grand jury clause of the Fifth Amendment to the Constitution provides no person shall be held to answer for a capital or otherwise infamous crime unless a presentment or indictment of a grand jury. Like the U.S. Constitution, the Arkansas Constitution contains a grand jury requirement, and so did the 1868 version of the same document. And Vinny, it goes on in the conclusion of this motion to dismiss to say, an individual's Fifth Amendment right to be free from serious criminal charges except those charged by the indictment of a grand jury shields not only this defendant but all of us from exactly the sort of deprivations of liberty without due process that the framers sought to prevent. So
he wants this in front of a jury,
and that's
like whether it's a grand jury or ultimately a trial in front of a jury. He wants the people to decide whether or not what he did was right or wrong.
That's exactly what he wants in layman's terms from the lawyer talk there. Right. And he has a hearing coming up on December 16th, and he's awaiting his trial that's scheduled for January of next year.
In January, in Arkansas. All right. Cody Thomas, great job. Let's bring back in our think tank, Joseph Krasky Jr., Bob Bianchi, Dr. Sue Kornbluth. Bob, there's a lot of layers to this whole thing. I want to start with, why is a guy charged with 43 felony counts against a 14-year-old victim out on bond to begin with? Is our system out of its mind?
You know, Vinny, the pendulum has swung from a place where we had people waiting in jail for 2 or 3 years for a trial because they couldn't make a $200 bail on a simple theft case, to a point now where serious felons that represent a continuing danger to the community, like this gentleman, are allowed back out on the street to re-victimize not only other people, but the same victim in this particular case where there's a no-contact order. Now, I'd like to think that my state of New Jersey's kind of got it right, because unlike a lot of other states, the danger to the community is a significantly weighted factor as to whether or not you are going to be released, and prosecutors often seek continued detainment based on that factor. How this guy got back out to re-victimize a 14-year-old girl and violate a no-contact order is ludicrous to me. And last point, before that would even happen in my jurisdiction, a judge would be ordering a psychosexual evaluation to see whether or not this person is a repetitive and compulsive potential danger to the community. I'd love to know if that was done here.
Let's look at this from a psychological standpoint, though, Bob, for a minute. I agree with everything you say. I think it's disgusting that this man was let out on the street again. But what we have here, I believe, is a father who, like many of us who are parents, are seeking out revenge. And that's never a great place to come from. And I think he's running so that he can say to the parents out there, let's watch what our cops are doing. But we can take things into our own hands at times. Now, when we take things into our own hands at times, you know, that leads to being arrested like he is. So I think this is a father that's fed up with the system and is running on revenge. My heart goes out to him, but this is not the way to heal.
So a couple of points, right? I agree it's unusual that someone charged with that would be released. Up here in Massachusetts, a much more progressive state than Arkansas, typically they would be detained if there was a judicial determination that they pose a safety threat to the community. So there might be some mitigation. There might be a lack of viability to some of the charges that would lead a judge to actually release this person. But the other issue, and the issue that we're really talking about here, is whether or not this is a good candidate to run for sheriff. A prosecutor reviewing the evidence believes that this person is responsible for murder. And although I think we can all relate, look, America loves vigilantism, doesn't it? It's in our movies, and I think juries like it, and that's why they want to get in front of a jury. But law enforcement has to come from a place of restraint and temperament, and they cannot come to the job with a personal experience that clouds their ability to effectuate that responsibility that comes with that title.
And do we really want somebody that... Sorry, Bob.
The founding fathers specifically stated that people who are being charged with a crime can run for office unless you're otherwise debarred in that state, and we don't know whether that's accurate. Apparently not, because he's allowed to run, because he is still, guess what, guys? He's presumed innocent. Have we forgotten about that particular part of the equation when we're talking about this? The man is presumed innocent. And so just because you get charged, we're in a political environment right now where both sides are filing charges against the other ones in order to get political advantages. And if we start telling people that they're not able to run for office merely because they're charged, watch how many people start getting charged for things they didn't do or for minor things. So I say go for it with this guy and let their state laws control as to what happens. You know what? In Rhode Island, there was a mayor who was convicted that was allowed to serve as the mayor while doing a prison sentence.
Do we really want somebody running for this kind of position that is filled with rage and anger? That's how it appears to me, and that is
presumed
dangerous.
Innocent. He's presumed innocent.
But isn't the person that was shot and killed, wasn't he presumed innocent as well? You condemned him. And now, conversely,
I
you're
didn't condemn
saying
him.
that this person's presumed
How did
innocent.
I condemn him,
agree.
Joe?
If they want to run him, because you were outraged that he was released and hadn't undergone a sexual assault evaluation. So, look, what's good for the goose is good for the gander. He can run. I just don't think he's a good candidate.
All right, we got to leave it there.
Well,
Great discussion.
The elected officials will decide that.
Yeah. All right. Think Tank staying with us, fired up tonight. When we come back, we're going to talk about what's happening down in Tallahassee. The grand jury meeting Leon County one day after Donna Adelson was sentenced. What's going on? We have all the facts next.
Do you swear or affirm the testimony you're about to give will be true? You may be seated.
Wendy Adelson has never been charged in her ex-husband Dan Markel's murder, but she's testified in 3 trials that ended with the convictions of her brother Charlie, his ex-girlfriend, and her ex-boyfriend. In exchange, Wendy received a specific form of immunity.
And are you here today pursuant to a subpoena?
Yes, ma'am.
All right, and that subpoena confers use and derivative use immunity to you, so nothing you say can be used against you in the future.
That is correct.
Okay. That doesn't mean you have full immunity from prosecution, but nothing you say here and nothing derived from it could be used in that prosecution. Is that your understanding?
That is my understanding.
While those courtroom statements can't be used against her to develop new evidence, prosecutors do have her police interview, the only one other time Wendy spoke to authorities about her ex-husband's death.
What happened?
Well, before we get into everything, I have to establish where you were and who you were with and so forth. Okay?
Wendy was questioned by police hours after the father of her 2 sons was found shot and critically injured at his home. When asked about their divorce in 2013, she called the relationship contentious.
Danny didn't treat me very well, and I'm so scared that maybe someone did this. Not because they hate Danny, but because they thought this was good somehow.
Would you ever ask someone to do something like this?
Not in a million years.
Okay. Do you think someone would do this for your benefit without asking you?
No.
Moments later, she oddly mentioned her older brother, Charlie, raising some red flags.
He makes a lot of jokes in bad taste. He said, I looked into hiring a hitman and it was cheaper to get you this TV, so instead I got you this TV.
Her comments led police to push for more answers about the Adelson family.
If somebody tried to kill my ex-husband, they should be prosecuted to the full extent of the law.
Regardless of who it is.
I mean, it would be different if I thought it were my brother, but I don't think it was my family. I'm gonna call my parents. And they're very angry with him, right? Like, well, this isn't like it's their son, but he's the father of my kids. And this is a very, part of my language, up situation.
Wendy's 4th time testifying is for her mother Donna's trial. Tallahassee attorney Stephen Webster, who represented Dan Markel before his death, testified at Charlie Adelson's trial and has closely followed the case.
I do believe the state is going to ultimately charge Wendy. I don't see any new evidence that has been developed based upon Wendy's testimonies, compelled testimony. So I'm really not concerned at all about any derivative use challenges should she ultimately be prosecuted.
Everyone is wondering, will Wendy be next? Well, let me tell you what happened today. There were a lot of rumors floating around the courthouse down in Tallahassee because the day after Donna Adelson was sentenced, the grand jury was meeting. Word was it's a big case. Julie Janae, Court TV anchor, was at the courthouse today and has more for us tonight.
Vinny, we are just one day out from that sentencing from Donna Adelson's case yesterday, and today there had been a buzz around the courthouse as to whether or not a grand jury may be meeting and whether that would involve the ex-wife of victim Dan Markel, Wendy Adelson. But what we are learning from our affiliate Capitol reporter here in Florida, Forrest Saunders, is that the grand jury is actually meeting here in the Leon County Courthouse for something that has to do with the state. Capitol prosecutors are using this facility in order to handle a grand jury presentment on a Hope Florida Foundation, so a political establishment type case but not one that we think it has anything to do with the Adelson case. So what remains is that Wendy Adelson has not been charged at all in Dan Markel's death. Her mother is going to be transferred to a prison, and one that she asked for, recommended by the judge yesterday, that she'll be going to some place that is close to Miami. We'll, of course, keep you updated on what happens in this case, Wendy.
Julie Janae on top of it. So Donna's going to Miami. All right, that's fine. But let's talk about Wendy. Let's talk about this family, Dr. Sue Kornbluth. I mean, basically from the beginning of the interview, she's mentioning Charlie's name, talking about Charlie, joking about the hitman. And guess what? Charlie hired a hitman. I mean, but she's never been charged. Never been charged. Are you shocked that no member of the Adelson family took the fall for everyone and just said, I did it, take me. It wasn't this one, it wasn't that one, it was me?
No way, Vinny, but thanks for saying that. They are the most, in my opinion, narcissistic, sociopathic family I've ever seen. Look, I do this every single day. This is my wheelhouse, dealing with divorce families in custody. And I said this at the beginning. Wendy Adelson is the mastermind of this. If you watch that interview, which I have watched with her and the police from the beginning, she's dropping names of all her family members that who could be involved, who couldn't be involved. That call to her parents looked staged to me. And just like Mama Donna, her tears look fake there too. This was a complete setup, and I hope that they go after her.
Well, I'll tell you what, Vinny.
So look,
let me give you an insight into prosecutorial perspective. These prosecutors have been methodical. I've had problems with some of the evidence in the case, but my opinion doesn't count here. Theirs does. They've gone step by step by step. And my feeling is, having been a homicide prosecutor for a long time, that these prosecutors believe that Wendy was involved in it. The issue, whether they can prove it beyond a reasonable doubt, may be a little bit of a stumbling block, but that grand jury is not convening for no reason. You either usually go to the grand jury to let a case die or to indict a case. And in my opinion, humbly, these prosecutors, if they have any belief that Wendy is involved, are going to say what I said when I ran a prosecutor's office. You know what? The case may be tough, but we believe that she did it, and I'd rather try the case and lose it than not charge her at all.
So here's what I think. A strategic decision was made from the beginning. The strongest case went first. Charlie, you had the connection to the actual people that were hired for the hit. Garcia and Rivera and Magabuna that had worked in his office. And then the next tear down, of course, would be Donna. I thought the case and the evidence presented against Donna was thin, other than the suspicious content of the cryptic texts. Now, you go down to Wendy, and I think the evidence is even less. Certainly she has motive, but motive isn't necessarily evidence of guilt. She obviously knew the schedule of her husband, and there's some other suspicious information and evidence, but I disagree a little bit. I think they've been cautious because they want to make sure they have enough, because I think they're going to be in it to win it, because they know this is a well-financed and resourced defendant.
That prosecutor, in my opinion, is gearing up for Wendy. And she has done a phenomenal job so far of going after every Adelson. And I think she's going to do it again here. These individuals, they have so much narcissism in them that they absolutely believe their own stories at this point. You could see it yesterday with Donna. And by the way, everybody, Harvey should be on the list too. What he said yesterday was disgraceful.
These prosecutors are tough. These prosecutors are unafraid. And right to my left is the Man in the Arena poem. They're not going to have a problem getting in that arena. And if it means they lose, they lose. They're not going to give her a pass, in my opinion.
Should they ethically go forward, though? You know, my concern with conspiracy is it's really a catch-all, and knowledge alone is insufficient to bring charges. And certainly there's an element that she probably knew what was going on. You have the drive-by on the day of the actual shooting. but no one has pointed me in the direction of any actual evidence that she was part of an agreement with the shared intent to kill her husband.
Well, here's what I think the evidence may show, and I think this is where prosecutors may lean on heavily, is that she is the one sort of providing the information about Dan's schedule, where he is and when he'll be there. And I think that may be the hook that gets them into all of this, because you need that information. You know, if a hitman's coming up, he's not coming up blind. He's got to know something. He's got to know the license plate. He's got to know the car, and he's got to know the schedule as well. And I think that may be enough. Joe, if that pans out, would that be enough?
Oh, it would be enough to charge her, but I know that she certainly was aware and cognizant of his schedule, but I haven't heard any direct evidence where she laid out as part of an agreement what his schedule is. There is information right from Lacasse that she knew he was going away, so it would have to be done that week. So probably enough to charge.
Well, we don't need direct evidence.
Connection between the two.
Great job by everyone tonight, Joe Krowski Jr., Bob Bianchi, Dr. Sue Kornbluth. Great to have you on the program. We'll see you again really soon. When we come back, I need to reveal something else you need to know tonight, plus coming up next hour. Tonight on Vinnie Politan Investigates, a quiet stretch of Long Island's coastline, home to sun, sand, and a trail of death. Families of the victims still search for justice as shocking new evidence emerges in the Gilgo Beach murders. Will the upcoming trial of the suspect finally reveal the monster who hunted in plain sight? Tonight, we investigate.
Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates, tonight, 9/8 Central, only on Court TV.
Spelling bees aren't about winning. They're about the journey and how we grow. The Believe Fund provides free enrollment for low-income schools. You can help give kids a chance to participate. If you believe in the power of words, DONATE today.
Time to reveal something else you need to know tonight. Let's take a look at the big board. What do we have? Caught on camera. This was a possible abduction caught on Ring camera in Wichita Sunday around 2 in the morning. Police had no idea who the victim or the perpetrator was. Let's take a look at the video. Scary video shared all over social media. Now we're hearing from Wichita police. The female from the doorbell video located safely this afternoon. Today at 3 p.m., Wichita police received a phone call from a female claiming to be the individual investigators were attempting to identify. Investigators immediately responded to her location, made contact, and transported her to City Hall for a further victim interview. Investigators are conducting interviews. Currently, we've identified the female's 35-year-old who lives in the area where the video was captured. At this stage in the investigation, we believe this incident is a case of domestic violence where the female was victimized by her boyfriend. She does not have any significant injuries. That's good news. All right, take a look at your screens. We need some help tonight, folks. There's a missing child. This is Brianna Whitfield, just 17 years old, missing out of Lakeland, Georgia, since October 9th. If you see Brianna, pick up the phone, make a call, make a difference. 911, 1-800-THE-LOST, or you can call the Lanier County Sheriff's Office in Georgia. That phone number's on your screen right now. Let's see if we can get Brianna to a safe place tonight. Don't go anywhere. We have another hour of live true crime. Vinnie Politan Investigates is next. In the meantime, please don't forget to hug the kids.